Good afternoon. It's a happy feeling to know that almost none of that applause was for me. We're really glad you could join us. I think it says something that on the Friday afternoon, right as spring break is about to commence, we have such a wonderful turnout for this terrific event. We're working them too hard. All right. When the justice says that, I guess we'll have to listen. So this is really a special opportunity for us at the school, a very special day, to be able to talk about the wonderful new book of our colleague Bert Neuborne, the just installed Norman Dorsum Professor of Civil Liberties here at NYU, and to be able to have that conversation with our wonderful friend, whom we admire so much, Justice Sonia Sotomayor. Welcome back to the school, Justice Sotomayor. We conceive of this as a conversation, but it will begin with a bit of a lesson from Bert. He'll spend some time outlining the argument of the book, and then the justice will lead us off with some questions, and the three of us will have a conversation that I think could run for hours, but that will run until about 5:15, and then we'll invite all of you to join us for a reception in Greenberg Lounge just across the way. But Bert, why don't you start us off?
Thank you, Trevor. Let me say a quick thanks to three people. Obviously, a thanks to Justice Sotomayor for graciously taking time from a really busy schedule to join us here, but more importantly for her human voice that is heard on the court and in the public square. And you know, Justice, that you always have a home here. This is a place that we love to have you. And to Trevor Morrison for his willingness to participate this afternoon and for his leadership of the law school. Despite what he looks like, he's not 15. He's really is an able dean, and he's leading us. And finally, to my publisher, The New Press, a nonprofit press that remembers the responsibility of a truly free press in placing new and challenging ideas before the public. And has helped in making the book available both to every federal judge and in donating the books that were outside for you. So I thank you very much for that. So let me take just a few minutes to lay out the thesis of the book before having to face my friendly inquisitors. I could have subtitled the book on reading the Bill of Rights, especially the First Amendment, in an age of text. Because the greatest change in my world as a civil rights, civil liberties, constitutional lawyer over the years, from when I started to now, is the importance of text. When I began as a young lawyer in the 1960s, text was an interesting jumping off point. It was sometimes even read from beginning to end, but it was rarely dispositive. Other things were dispositive. I often say that we used text in those years as a kind of translucent window into something else. Sometimes we talked about purpose, sometimes we talked about policy, sometimes we talked about coherence, but we very rarely worried about the text. And one of the great triumphs of Justice Scalia's work on the court over the years, with help from a number of the other justices, was to remind us that text does play an important role, and that we should be spending more time about with the text. So I asked myself, okay, if I took that lesson seriously and rolled it over onto the Bill of Rights, and said, let's see if we can read the Bill of Rights, especially the First Amendment, and be serious about the text, what would I find? Well, the first thing that you find, let's concentrate on the First Amendment here. The first thing that you find is you can't read it literally. The idea that there's a literal First Amendment collapses with the first word, which is Congress. Because the last thing you want is a First Amendment that only binds Congress. You want it to bind the president, you want it to bind the police, you want it to bind the military, you want it to bind the government. So we read Congress as the government. The fourth word is law. Congress shall make no law. We don't want it to just be law. We want it to bind regulations. We want it to bind the policeman on the beat when he exercises his discretion. We want it to bind everything government does. And then the seventh and eighth words, Congress shall make no law abridging the freedom of speech. The freedom of are three crucial words that don't have literal meanings. Somebody has to think about what's inside the freedom of and outside the freedom of. And the words don't tell you. So I gave up on reading it literally. So then I decided maybe I could read it use Justice Scalia's invitation to read it as an original document. What's the originalist reading of the First Amendment? Well, the big embarrassment there was that the ink was not dry on the First Amendment before John Adams locked up 17 of the 20 newspaper editors who opposed his re-election in 1800. And if you then look at the rest of the history of the First Amendment, you realize that we had a feeble First Amendment until the middle of the 20th century. It wasn't until 1960s that we began to develop a serious First Amendment. So if you read it literally, it gets you nowhere. If you read it in a historical way, you either get into huge arguments about what they meant, or if you take the history seriously, you wind up with a watered-down First Amendment. So how do they read it now? Now the Supreme Court tends to read the First Amendment and the entire Bill of Rights as a series of isolated phrases that they tear from the text. The Free Speech Clause, the Establishment Clause, the Eminent Domain Clause, Cruel and Unusual Punishment Clause. They tear those words out, hold them in the palm of their hand, and attempt to figure out what the words mean. I'm going to try to urge you to think that that is not the best way to be serious about text. Because what you wind up with is, the text plays an important role, but it plays an essentially rootless role. Because when you pull words out of a text that way, you wind up with textual guidance, but no real context within which to put the text. And so the thesis of my book is that we don't have to read the Bill of Rights that way, especially the First Amendment. We shouldn't read it that way. We shouldn't read it as an isolated, we shouldn't read 7 words in the Free Speech Clause. Congress shall make no law abridging speech, because we ignore the freedom of all the time, and think that what we have is the First Amendment. What we have is a very powerful tool, but it's a rootless tool that can be both arbitrary and that can swing in strange and unpredictable ways. So I thought to myself, is there something in the text that is deeper than pulling out a couple of words? And to my surprise, because I didn't think I'd find it, to my surprise, it turns out that there is a deep structure in the Bill of Rights, a deep structure in the First Amendment and a deep structure in the Bill of Rights itself, that if you read the 45 words, all 45 words, all 6 clauses in the First Amendment, and all 462 words in all 10 amendments of the Bill of Rights, if you insist upon reading them as a coherent whole, as I call a poem or music, whatever metaphor makes you comfortable, but if you read it holistically, as an entire whole, it tells you a story. The First Amendment, for example. First Amendment consists of 6 clauses with 5 basic ideas in 6 clauses. The 2 religion clauses are all about freedom of conscience. They're all about, the Establishment Clause is you should be free from religious pressure. The Free Exercise Clause is you should be able to exercise your religion freely. The Speech Clause is you articulate your ideas. The Press Clause is that the ideas get disseminated to a mass audience. The Assembly Clause is that you have collective action in support of the idea. And the Petition Clause is that it gets presented to the formal legislative apparatus for adoption. If you think about it that way, it is the chronology of a democratic idea, born in the free mind of a citizen, articulated through free speech, disseminated to the entire population through a free press, acted on collectively by the population under assembly, and then formally either voted up or down by the formal legislative apparatus. There is no other document in our rights-bearing history, from the Magna Carta down. Madison had 42 documents that he could have worked with. There is no document in the 42 source documents that he had that comes close to replicating such a remarkably orderly presentation of how a democracy operates. And so it seems to me that if you're reading the First Amendment under those circumstances, you must at a minimum take into account the fact that you are reading an enabling document. You are reading an enabling clause or an enabling amendment that attempts to make democracy work. It is a blueprint for a functioning democracy. And it is not, as some of the justices read it, it's a device outside of democracy. that is essentially a disciplinarian mechanism that disciplines democracy. It's inside democracy. It is the functioning organism that makes democracy work. And I'm sure I'll get asked this question in the question, but I think it changes the way you read the text. Instead of reading isolated pieces that you pull out of the text, if you have to read the text as, how do I read this blueprint for a functioning democracy? In this particular context, you begin to ask yourself, what's the best structure of democracy? How do I, as a judge, help democracy function? And the justices don't ask themselves that question. Indeed, they think they shouldn't ask themselves that question. And I think we wind up with a First Amendment that has turned out not to be democracy's best friend, but is turning out to be democracy's bad parent. That is unduly disciplinary one day and completely absent the next. And so my plea is that we go back into the text, take text seriously, take Justice Scalia seriously, read the text, and see what the text of the First Amendment tells you about it. Now, you can do the same thing with all 10. Because if you say, all right, the First Amendment is a story, a poem, a great story about democracy, about free thinking, free speaking, mass dissemination, collective action, and eventually political adoption. If that's how we see the First Amendment, then we see the 10 amendments laid out in also remarkable order. The First Amendment is the city on the hill that the founders hoped to create. Second, and then the rest, the Second through the Eighth Amendment, is a remarkable listing of the dangers to the city on the hill that the founders perceived, and an effort at creating institutional corrections for them. Second and Third Amendment is the death knell for most democracies: military overthrow or military subversion. There's a reason why the second comes right after the first. It's not random. The second is the greatest danger. And the question is, how do we, and I hope I'll be asked that, how do we integrate the Second Amendment into a holistic reading of the Bill of Rights that makes it relevant today? The Fourth through Eighth Amendments, the criminal procedure amendments, are a remarkably disciplined chronological recapitulation of the criminal justice system. The Fourth Amendment deals with investigation and with arrest. The Fifth Amendment deals with interrogation and charging. The Sixth Amendment deals with adjudication, and the Seventh Amendment deals with adjudication in civil cases, and the Eighth Amendment deals with punishment. It couldn't be listed any other way. The order is perfect. Now, it might be that monkeys with quill pens wrote it that way. It might be random. But it's I think not very important whether it's random or not. The truth is, it's the words that speak to us. The words speak to us showing a coherent First Amendment with a remarkable story of democracy and a coherent listing of the dangers to the democracy with important institutional controls. And then the Ninth and Tenth Amendments are the rules of reading. They are the rules about how you read this remarkable text. Because the one thing Madison knew was how slippery text was, how hard it was to read text. And so Madison ends his Bill of Rights with a command or an authorization in the Ninth Amendment to read rights broadly, to not be afraid to expand them through a disciplined process of analogy when it's necessary to make the rights work better. That's just what Justice Harlan did in 1958 when he interpolated freedom of association into a First Amendment text that does not contain it. He put a seventh idea in there because it was analogous and necessary to make it work. And then the 10th Amendment is Madison's command to read powers narrowly, jealously, that you read powers and the simultaneous reading of rights broadly and powers narrowly is what ultimately keeps us free as a people. So my plea is, when you go home tonight, I've said this once and at my inaugural talk, but I'll say it again. Go home tonight. Take the Bill of Rights out of whatever place you keep it and never look at it. Give it an airing, give it a little walk. Take the Bill of Rights out. It's more important than what lawyers do. It's even, God bless you, more important than what Supreme Court justices do. It is our founding text. Take it out, and it can be read by lawyers and lay people. Take it out and read it and see what it tells you. See the story that it tells you. Don't be afraid to read it as a whole and see if it changes your idea of what the text is. That's the challenge of my book. And my hope is that people will take it to heart. Thank you.
Well, before you go home to take the Bill of Rights for a walk, feed it, etc., we have some questions. Justice.
I worked very hard at a list of questions, and it's a good thing you invited me to go off text.
Yes, well, let me say that I will not accept a grade for this.
So I'm going to go off text immediately, because the question was provoked during your talk.
Sure.
If you're viewing the First Amendment as a structure for democracy, then do you believe, as some past justices have, that the First Amendment is only about political speech? Because if its intent is to structure a democracy in which people are circulating ideas, have a free conscience in doing so, have the right to have it disseminated, and it ends with petition the government, then there's some validity to viewing it just as.
Well, it's a great
Political speech.
It's a great question. I should have known her first question was going to be a great question. My answer, although it is an answer that it raises as many questions as it purports to put to rest, my answer is that the First Amendment clearly goes beyond politics, because no functioning democracy can function well in an atmosphere in which the arts and literature and the ways that we train our mind to be minds of inquiry and minds of free thought, that is a precondition to the functioning of a free democracy, and that every idea that has political resonance is not a political idea. There was no coincidence that every dictator that we know, from Hitler to Pol Pot to Mao, hated innovative artistic work, and revered classical work. Classical art was good art. Innovative art was bad art. Why? Because innovative art trains you to see things differently. It challenges you to see the world differently. So I think the Supreme Court was exactly right. They had to confront this in the 40s with movies, for example, but they've confronted it over and over again, that it is true to the ethos of the First Amendment as a great protector of democracy for the justices to say, can't have democracy without having an effective protection of art as well.
I'm going to follow up, because
Okay.
I do want to have a conversation.
Oh, absolutely.
In
Hey,
your book-
why should this be different than the courtroom?
There's no red light, I don't think.
And,
but there-
That's true, thankfully. By the way, it's a fun book for someone who's not immersed in the law, because just as he's clear here, his book is clear as well. And it's so well written that I heard Bert's voice in my head as I was reading it. And I consider that the highest of compliments to an author. And do not skip the first page, the dedication to his father. I spent over 200 odd pages in describing the impact of my mother's life on mine, and he did it in one page. Okay, he can summarize in a beautiful way. I won't give it away because I want you to read it. But going back to your point, you know that we have, despite the fact that we say we subject everything to strict scrutiny, we really don't, and we don't. But, and we don't because we have a different standard of scrutiny for things like commercial speech, for example. under your theory, would that difference in standards be appropriate? And then how, and if you're talking about freedom of art, your book criticizes the Supreme Court's decision in the Crush video context of torturing animals. So how do you reconcile what you've just said with those two views?
Well, my reconciliation, or my attempted reconciliation, is that just because something's protected by the First Amendment doesn't mean that it's absolutely protected. If you say that the First Amendment is designed to deal with art, or if you worry about whether commercial speech is within the protection of the First Amendment, you begin to inevitably develop tiers. That's what we've done. And in fact, we developed tiers of protection in the First Amendment, in large part in resonance to the idea that political speech about democracy is the core. That's where it all begins. That is the core. Despite the fact that the court has never acknowledged the 6 ideas as being democracy ideas, they've over and over come back and said that the core is political speech. Then you move out from the core to artistic speech, to commercial speech, and inevitably, as you move from the core, you're going to get state interests in regulation, some important interest in regulation. I've never believed in an absolutist First Amendment. I've never believed that Justice Black used to have the original copy of the Constitution that was the true copy in his drawer, and he used to be able to pull it out and look at it and said, I know what that means. Nobody else did, but he knew what it meant. And he said that there was an absolute First Amendment. I never believed that. I always believed that what it was a statement that the kinds of things that the First Amendment was designed to protect were enormously important in the society, and that we should never overrun them unless there was an absolutely important reason that we couldn't figure out any other way to do. And much of First Amendment doctrine is faithful to that. The idea that you need a compelling interest, that the compelling interest shouldn't be able to be advanced by less drastic means, that makes good sense. Because what we're doing is we're forcing an error deflection. We're forcing the legislature, or we're forcing the government to say, before you move to the easy target, the speech target, and get rid of it, because there's some very important thing that you're trying to protect, first experiment and make sure that there isn't any other way to do it. And I think that's a great message. It's a message that keeps us free, but doesn't say, if there isn't any other way to do it, that you can't then regulate the speech.
All right. You say that, again, that the focus on the First Amendment is democracy. You invite your thesis as a different way of interpreting the Constitution. So who decides what promotes democracy? And people disagree about it all the time. So how do you define democracy? And is it something like one person, one vote? What are its structures?
Well, I'm sort of shocked that you answer that, because that you ask that, because it's clear I defined democracy.
No, you forget, I do. You know I was just jesting.
Nobody ever accused me of being anything but a great straight man.
Powerful evidence that faculty really feel quite powerful.
The answer is, I think, in an exchange between Chief Justice Roberts and Justice Breyer, whose writings have influenced my thinking on this a good deal, in the McCutcheon case. In McCutcheon, when the Supreme Court declared unconstitutional efforts to place a limit on the amount that any extraordinarily wealthy person could contribute to a single election cycle. It was $123,700 in a given election cycle. When they declared that unconstitutional as a violation of the First Amendment, in the dissent that Justice Breyer was writing, he complained that this was creating a very bad democracy, that this was not good for democracy to essentially allow the rich to be able to use the enormous power of wealth to essentially buy a bigger megaphone than anybody else could buy, and to make their speech more powerful than other people's speech just because they could afford to do it. And he said, you know, you're winding up with a democracy that is not a particularly attractive democracy. And Roberts responded by saying, that's not the right question to ask. That's not our question. That's not what we do. What we do is we enforce the First Amendment. If it creates a bad democracy, it's not our fault. We fix that by amending the Constitution to get a better democracy. And the two visions of what they should be doing when they're reading the First Amendment were struck home to me, because the Chief Justice was perfectly plausibly saying, I am reading the First Amendment as a deregulatory device, as a device that simply takes the Supreme Court out of the game when we're regulating communication. And of course, that's one of the reasons why conservatives like it so much, because it fits into a general deregulatory philosophy about government. And this is simply applying that deregulatory philosophy in one very important area of American life. I thought that what Justice Breyer was saying is, no, the First Amendment is not just deregulatory. It's deregulatory in many settings, but it's also aspirational. It's also an effort to set up this ideal polity that we want to live in, and that it is not a matter of indifference to us in reading the First Amendment what kind of democracy comes out the other end. It should be one of the most important things we do, is think about what kind of democracy comes out the other end. So then there's the second half of the Justice's question. So who gets to say what's the best kind of democracy? And that is an issue that we will argue about, that I'm sure the justices would argue about, I would argue about it. But let me paraphrase Justice Scalia's answer to a sort of similar question years ago. Years ago, when Justice Scalia was defending originalism, he originally defended originalism as claiming that it would give us a single right answer to things, that we would go back in time, find out what the founders wanted, and just enforce it. It turned out when we went back in time, we would find that the founders were often as divided on important issues as we were, and there would be a history that would go in either direction, and that you would have briefs that were made up of my history and his history, and then you would have to pick which history you bought. And so when Justice Scalia was confronted with that, saying, look, don't you have to make choices? He said, I would rather make a choice about history than make a choice about values. He says, what I'm trying to do is force judges to make choices that I don't consider to be illegitimate. And choosing history is different than choosing values. I would have found that a compelling answer if every single justice didn't always happen to find the history that happened to advance their values. But that was his answer. My answer would be, I don't know what will be the final denouement of a judicial discussion about whether unlimited campaign spending is the best way to have a good democracy or a bad democracy. But I would rather have judges asking that question among themselves than pretending to decide the case by deciding what 7 words mean, Congress shall make no law abridging speech, and having it sort of be automatic without even thinking about the consequences of democracy. Because I believe that the Supreme Court in the last 60 years, since Baker versus Carr, has helped us build an appalling democracy, a democracy that is essentially failing us because no adult was home while the democracy was being built. They decided First Amendment questions. They decided equal protection questions. They decided separation of powers questions. They decided equal protection questions. They never asked themselves, are we deciding democracy questions? And so what we wind up with is a democracy that comes out of that chute, which is like an architect. An architect builds a building, and it's a gorgeous building, beautiful. Windows, doors, stairs, it's gorgeous. The only trouble is nobody paid any attention to whether the stairs actually went up to a floor or whether the windows ever opened anywhere. So the building is gorgeous, but nobody wants to live in it. Our democracy may have gorgeous doctrine, but I don't think we want to live in it, because it is not the democracy that Madison hoped for, that the founders hoped for. And I think we went wrong by the justices not accepting the responsibility for arguing about what is the best democracy? And of course, the justice is right. She's the one that's going to have to decide it.
So Bert, can I follow up with that? So what's interesting about the presentation here today and in the book, I think, is it's quite, I think I'm right in reading it as saying quite openly that you want the master question in the First Amendment to be, what would best promote democracy? So this is a fairly open, I think, acknowledgement that your approach to the Constitution is one that we might call constitutional perfectionism. That is, that the question that, and as you said earlier, you read Madison's music and it's perfect. And so I want to make sure that I'm right in that understanding by posing this question. Does your approach to the text of the First Amendment that we have amount to the same approach that you would advocate if the text simply said, individuals shall have rights to be free from those forms of government intrusion that would undermine the best functioning of democracy, period? And if so, and if you think there would be difference, I want to know why, because that just seems the using fewer words to state that the constitutional norm is one of perfect democracy. And if you would say there would be no difference, perhaps you regret that the First Amendment doesn't say that, because that would force the value choice that you want. And if you'll permit me a third part.
A third part? I can't even remember the first part.
Right. Since the First Amendment in its particular text is globally unique, it leaves the rest of the world in an odd posture when they do constitutional interpretation with respect to whatever democracy-promoting clauses are in theirs, because presumably you would say those are good, but not perfect.
Yes. Okay. So let's start with the first one. The first one is, do I think that the First Amendment, the way I read it, as a story, as 6 integrated clauses that tell the story of the birth and eventually articulation and argument and adoption of a democratic idea, do I think that that is simply a statement saying, do the best you can to get the best democracy you can? And my answer is, in some sense, that's the end question that they should be thinking about. How am I best going to promote democracy? But I'm not unaware, I mean, and nor am I disrespectful to the fact that there are 45 words there, that it isn't just a sort of democracy now. First Amendment, democracy now. It's a blueprint. It's a blueprint. The blueprint says we start with worrying about free conscience. We worry about starting with establishment and starting with free exercise. And there's a reason why he started there. There's a reason why the first words of the first are about religious conscience. As many of you know, there was a third clause that got lost. The third clause was a secular conscience clause that Madison wanted to put in there, saying that secular conscience is protected as well. It went through the House, and the Senate knocked it out just before it went out for ratification. And people never know. Some people argued that they thought it was redundant, but since the Senate met in closed session in those days, we have no history of why Madison's secular conscience clause was dropped. But it seems to be no mystery about why, when he was putting this stuff together, he started with conscience. So it wouldn't be, do I think conscience is a good idea? How do I do conscience? I start with a mandate that I have to worry about free conscience if I'm going to be able to have a functioning democracy. I'm told that. I'm then told that the way to have a functioning democracy is, once the thought is born in the free mind, then I have to be able to make sure that individuals can articulate it, speech, that they are not frightened and not under threats of sanction for doing that. But then, and here's where it's most important, then I have a press clause. The existing First Amendment suppresses the press clause. What we have is an imperial free speech clause that has essentially conquered the press clause, conquered the petition clause, and subverted the assembly clause, and is even now telling us what the establishment and free exercise clause mean. It's those 7 truncated words that have now captured the rest of the text. I think a Supreme Court committed to Madison's music has got to think about what a free press looks like in a functioning democracy, and has to actually amplify and fill out the press clause, not to simply say the speech clause does all the work. There is a press clause, and the press plays a special role in a democracy that is both specially protected but also potentially regulated, of access to the mass organs of communication. And so I think a careful press clause might look very different than we have now. An assembly clause would look enormously different. Assembly clause would never have allowed Occupy Wall Street to have been suppressed that way, like that, without any real reason. An assembly clause would have actually said, assembly is the only free speech there is, because it's free, and poor people can use it, and they can speak with their bodies, with a communication paid for in sweat equity, and that you don't suppress that easily under the time, place, and manner rules that we have now, that essentially make a freedom of assembly a kind of tolerated speech minus that we'll use. And the petition clause is dead. The petition clause was once enormously important. John Quincy Adams led the fight for slavery, to abolish slavery when he was in the House of Representatives by essentially using the petition clause. Every single day, a petition to abolish slavery was introduced into the House of Representatives. Every single day. To the point where they actually had to put a gag rule on him to stop him. And the gag rule was declared unlawful by Congress in 1844, and it's no coincidence that 1844, you get the petitions coming again, and there's the Compromise of 1850. There's some effort to deal with the issue. But the petition clause has no meaning now. So my answer to you is it tells us not just to have a good democracy, but it tells us what the components are and makes us focus on the components of each. And I think ultimately, although this is a reach that we don't have time to talk about today, there's a right to vote buried in there too. If we wanted to derive the right to vote the way Harlan derived the freedom of association, a non-textual right, there is a right to vote hovering in the First Amendment, just waiting to be discovered.
Why do you put it there? Why do you put it there? Why
Why-
not
oh,
put
why
it?
did- why-
No. And I ask because I have. Earlier, Bert said that this democracy, if you read the 9th and 10th Amendment, presupposes us reading rights, individual rights, very broadly, and government powers very narrowly. And if that's the case, I'm assuming, you can tell me if I'm wrong, that you do believe in substantive due process in some form.
I don't,
But
actually.
you don't?
I don't.
Then why not just house it in the 9th Amendment?
Well, that's what, see, again, it's such a perceptive question, because really, there's a reason why she gets to decide what democracy means and I don't. That's a very, very perceptive question. And the way I think it works, actually, I mean, this is that the 9th Amendment has been an underutilized amendment. It was originally seen as a way to import natural law into the Constitution, and that's a mistake. We can't do that. Remember what the 9th Amendment says. The 9th Amendment says that just because rights are not listed in the Bill of Rights doesn't mean they don't exist. They're still retained by the people. And that it was a sort of act of humility, saying we're not sure we're going to get them all right. We're not sure we're going to list them all. And one of the reasons why Madison was not thrilled about doing a Bill of Rights initially is he was afraid that he was going to leave something out. And if he left something out, he imagined some future Justice Scalia saying, well, you left it out. If you left it out, we can't put it in because it's not in the text. And so what Madison, I think, did is use the 9th Amendment as a way of fixing that. The 9th Amendment is a window that says we can add rights if we have to, if we find it necessary, and we can add them judicially, that judges can add them through the 9th Amendment. And they can add them in a way that the lawyers of that time knew. There was something called the equity of the statute. This is, for those of you who are not antiquarians, if you're lucky, you'll never hear about this again. But there was something called the equity of the statute that British Parliament used at about this point to expand the text of a statute. If a statute said that any servant who strikes his master shall be hung. They used equity of the statute to say, well, if a woman servant struck the master, even though they used the word his, her would be put in there also. You would analogize her. And so it wasn't just pure text, it was text plus analogy against the background and context of the statute. I think that's what Madison was doing with rights. Madison was saying, if we live into the next century, into the next 2 centuries, and we find it's a world that requires different rights or expanded rights, don't be afraid to expand them. I think that's what Justice Harlan did when he found freedom of association. Freedom of association is a perfect example of the appropriate application of the Ninth Amendment. And it's not open-ended because you have to use the careful, disciplined, you have to say it's not inconsistent with text, and it's analogous to something we've already protected, and it's important to make the structure work, in which case it's appropriate to recognize a new right. So that's what I would use to substitute for substantive due process.
You're arguing, or at least in sync with Justice Goldberg and Griswold.
Yes, it's the Griswold. Although,
for those of you who are interested in following this up, there is at least one justice who has approached some of these questions in this way.
in the Ninth Amendment, that's right. And instead of filling out the Ninth Amendment, as the Justice points out, we went down a substantive due process road, which I consider to be, the reason I'm troubled by it, it's utterly without standards, utterly without controls. And I get nervous about having nothing to argue about, except do you like the right or don't you like the right? I would like to have something else to argue about rather than that.
You spoke a little bit about the court going astray on Madison's music, sort of going tone deaf in campaign finance. So I'm going to take you back there. How does, and you didn't really answer this, how does a Madisonian judge strike the balance on those laws?
Well, again, great question. What I hope is better than a feeble answer, but it's the best answer I can give. Let's go back to some of the real cases. I mean, Buckley versus Vallejo is where all this starts back in 1976, when the Supreme Court makes 4 judgments. 4 judgments that essentially have created an airtight box, a box, within which any effort to reform the use of money in the system operates. They first found that there is a one-to-one correlation between spending money and speech. That spending, I actually believe that there is a correlation between spending money and speech, but it stops at some point. I don't know exactly where, and one can argue about where it stops, but spending $1 million to push your idea is different than spending $10 to push your idea. There comes some point at which the spending simply becomes an exercise of power and stops being an articulation of an idea. And so I always wondered whether the court was right in saying in Buckley that the spending of money gets the same protection that the articulation of words will receive, as the justice points out, strict scrutiny, the highest level. The second judgment they made was that equality, political equality, one person, one vote, the idea that we all have the same equal political rights, is not a sufficient reason to regulate the amount of money that's being spent by very, very wealthy people in the process. I think that's just flatly wrong. It's not like it was an idea that was thought to be crazy. Skelly Wright, who was a pretty good judge, and Spotswood Robinson in the D.C. Circuit said that fostering equality, fostering political equality, is a compelling interest and would justify the regulation. But we lost that battle, and so equality doesn't count. Then the third argument was corruption counts. You can do it to prevent corruption, but only the kind of corruption that is quid pro quo bribery. If something corrupts the system, because people now just pay attention to their rich donors and don't try to work out anything for the common good, that's okay. That's not corruption. So they adopted this narrow bribery, quid pro quo definition of corruption, and then they adopted a distinction that I genuinely, to this day, don't understand. And that's the fact that contributions can create a risk of corruption because you give the money directly to the candidate, but the unlimited spending of money without coordination with the candidate doesn't create a risk of corruption. As though the candidate only runs once and isn't worried about getting the money the next time, and the time after that, and the time after that. So that independent expenditures, of course, influence the way the candidate is going to operate with the individual. You put those four things together, and there's nothing you can do to regulate money. I think that was a tremendous mistake. And I think what they should have done is say to themselves, as Skelly Wright said, as Spotswood Robinson said, what kind of democracy are we trying to protect here? What have we fought so hard to achieve? Why did one person, one vote matter? Why did we spend half a century trying to create equal voting rights? We did it because everybody's political power should be equal in a democracy, and money shouldn't corrupt that idea. I think that's what a Madisonian judge should do, and I think if they adopted a Madisonian reading of the First Amendment, we would change campaign finance regulation overnight. Now we'd have a debate, the good debate. The good debate would be, is that good or bad for democracy? Is it good or bad for democracy? And we'd have to worry about fear of government, which should play a role in that debate. We'd have to worry about all the things we care about when we worry about the First Amendment. But the question we would be asking ourselves is, what kind of democracy do we want, and how can we get there best? If the judges are talking about that, we can't lose. We can't lose, because maybe it'll be a democracy that is not exactly what I want, but it will be a democracy infinitely better than the one we're living in now.
You know, I have a problem with that only because of my colleague, Tony Kennedy.
Yeah,
You
I know.
know that Tony, like Steve Breyer, think about democracy a lot, and that Tony's approach, unlike some of my other colleagues, is born on a very, very, almost fanatical belief that democracy, that the essence of democracy is no regulation of speech.
Yes.
All right? And so you say, you know, you rather have us talking about it and it's likely to come out better. But how do you choose between those ideas? And you also criticize judges making those decisions.
Well, I do.
Because we're an unelected branch.
Well, let me say a word about Justice Kennedy, because I toasted him here with great respect and great affection as the most important First Amendment judge that has ever sat on the Supreme Court. More important than Justice Douglas, more important than Justice Black, as the most dedicated First Amendment vote that exists on the court. In his whole career, I know of one or two votes in all of the enormous number of votes that he's cast over the years that have not been strong pro-First Amendment votes. And so he is a remarkably important protector of free speech. And I criticize his jurisprudence with respect to campaign finance, in that I'm afraid that what he does, and this is where I think the conception of the First Amendment is important. I think he thinks about the First Amendment as a deregulatory device. I think he thinks that if you let government have any control over speech at all, that will inevitably be terrible. They will inevitably abuse their power, and they will inevitably make democracy worse than if they hadn't stuck their fingers in there in the first place. And therefore, he has no difficulty, I think, in simply saying, I will just completely take an eraser to anything anybody tries to do to regulate speech, and what comes out the other end is going to be better than if I'd let the government do it itself. I respect that. That's certainly not an impossible position, but it's not the only position. I mean, if you think for a moment, and I'm going to do something controversial, because I'm not sure everybody agrees with this, but I'm going to, and of course I never do that. I'm going to suggest to you that this idea, the justice was teasing me about it. In my book, I say that Mr. Madison's neighborhood consists of 5 people. 5 people live in Mr. Madison's neighborhood: the speaker, the hearer, the conduit who transmits the speech, the target who the speech is about, and the regulator. And I said, what we do, if you had to do a social history of the neighborhood, the speaker is the aristocrat. The speaker almost always wins. The speaker's interest almost always predominate. And it was the case about the porn, the animal porn of stuff crushing small animals in a way that I found viscerally disgusting, but also I couldn't figure out how it advanced anything and why we should care, not about protecting this guy, but about giving him a windfall by striking the statute down on the grounds that it was void for vagueness. I didn't know why we should give this guy such tremendous capacity to escape. So that's the speaker. The hearer is the haute bourgeoisie. Important, but when the haute bourgeoisie goes up against the aristocrats win. And so hearer interests almost always get subordinated to speaker interests. And maybe they should, but maybe the hearer interests are undervalued, like the family that was celebrating, that was engaged in a funeral for the burial of their child who died in Afghanistan, and had to deal with a group of demonstrators who were saying that this was appropriately God's wrath because we treat gays too well in this country. I don't know why that demonstration couldn't take place the next day. I don't know why it had to take place close to the funeral. I don't know why it had to add to the grief of a grieving family. And I don't know why the First Amendment immediately says the speaker wins in that situation. I'm troubled by it. And then there's the conduit. The conduits are the big media companies, the 7 media companies that own everything. They own every single form of distribution, except the new press. Every single form of distribution in the country. And they've persuaded the Supreme Court to allow them to dress up as speakers. They say, we're speakers. We're not the technicians that are simply amplifying other people's speech. We're the speakers. And so they get to be the neighborhood Aravists. They get to be the speakers. And then there's the slum dwellers who are the targets. You can do anything you want to them, and they don't have many rights. And then there's the motorcycle gang. The motorcycle gang are the regulators. If you give the regulators any traction, they'll trash the neighborhood. That's the way we treat it. I'm not sure that that's empirically right. It's right to be nervous about the government. It's crazy not to be nervous about the government. No government that's ever got its hands on speech didn't try to manipulate it for its own good. So you've got to be very careful about the government. But this is a country that has run a public education system for considerably more than 100 years. If you want to say that if you give government power over the regulation of the transmission of ideas, you will inevitably run into government tyranny and a horrible parade, a parade of horribles that ends somewhere with Mao Zedong. Then you have to explain to me why public education, with all its problems, with all the facts that it does occasionally fall short, why it has succeeded, basically, in training generations of people to be citizens in a democracy and to ask free thoughts. You want to see single idea places? Go to a private school.
Not this one.
It's the private schools. So I don't. My argument is stop. And if I had a chance to have this discussion with Justice Kennedy, I would beg him to say, stop being so frightened about letting the government have any role. Keep an eye on them, but it doesn't have to be no role whatever. So that would be the.
All right, I got to give you a chance to talk.
Okay. Well, this has been a fascinating conversation. Bert, there are areas where you're worried about government dysfunction, maybe even more than the court is. I'm thinking about, let's say, partisan gerrymandering as an example. And so that reflects an attention that many have to circumstances where I guess the majoritarian actors in government are doing something that might undermine the premises for otherwise deferring to the outputs of majoritarianism. But how do you fold that in for me in terms of how you would tell a larger story of judicial review
Yeah.
in relation to democracy.
Yeah, the justice asked me a question like that. She's saying, is it really judicial review I'm troubled about, or is it reading the text in this clause-bound way that I think reaches uncomfortable results? It's not judicial review. I believe in judicial. I believe very strongly in judicial review. I believe that one of the brilliance of the structure is that judges are there as guardians to prevent self-interested political entities from going too far in protecting their own interests. Wouldn't bother me one bit if they struck down the stuff on the First Amendment because it was being used by the government to advance inappropriate ends. What troubles me about it is they strike it down on the possibility that someday it might be, without waiting to see how it actually plays out. It's a kind of prophylaxis, and I think the prophylaxis has been taken a bit too far. But for political gerrymandering, that's one of the, when I was kidding at the beginning of the talk about the First Amendment being democracy's bad parent, because it's overly disciplined one day, which is the case with the campaign finance, but completely absent the next. I was thinking about partisan gerrymandering. Yeah. I mean, because that's what we'd have now. We have two simultaneous streams of decisions coming from the Supreme Court. One, creating an airless box within which money cannot be controlled in the political process, and secondly, simply stepping away and saying there's nothing we can do about the epidemic of partisan gerrymandering that has essentially removed contested legislative elections as a significant factor in American democracy. If you look at any House race, every 2 years, every House race, take a look at those House races. If there are 40 of them that are contestable out of 435, it's an interesting year. If there are 60, everybody goes crazy. Usually it's about 30. And this is using the criteria of the American Political Science Association, where you know in advance that if it's a 55-45 district, you know who's going to win. If it's a 65-35 district, you know who's going to win by a landslide. Virtually every legislative district we have in the country meets that criteria. Legislative elections in this country have nothing to do with who wins. Because we know who's going to win in 85-90% of those cases, and it's even worse at the state level. A quarter of all state legislative seats are uncontested because the lines are drawn so that they can't possibly be contested. Now, you can't always get a competitive election. People live together. You're not going to get a competitive election in Detroit. You're not going to get a competitive election in Harlem, and you're not going to get a competitive election in Wyoming, because people all live together with similar political views. But in at least half of the districts in which we have no choice because the politicians decide who's going to win in advance, you could have drawn those lines differently. We could have drawn the lines in North Carolina differently. We could have drawn the lines in Ohio differently. We could have drawn the lines in Pennsylvania differently. And they would have resulted in genuinely competitive elections in a number of those seats, instead of no competitive elections in any of them. And my argument is that if you were reading the First Amendment, the way I hope a Madisonian reading would be, it's that one of the things we are assured as a people is being able to cast votes in contested elections when those contested elections are reasonably possible. And that if you have a system that is designed to prevent contested elections, there's something wrong with the democracy that's coming out of that. And that it is the judicial role to intervene and to attempt to do that. Now, 4 of the justices, including one who's sitting here, are willing to do that. 5 of them are not. But we've got to, I think, push the court into taking partisan gerrymandering seriously.
Now, why don't you give us an example of reading a cross amendment? So you speak briefly about your idea of the Second Amendment as structural protection of First Amendment democracy against military overthrow. Mm-hmm. So can you cash that out a bit for us? That talk practically about what a Second Amendment doctrine would look like that was musically Madisonian.
I'm glad to escape from the First Amendment, which was beginning to oppress me.
Your book.
The Second Amendment. So, why is the second? Why does it have pride of place? Why is it right after the first? What is it supposed to do? My thesis is that military overthrow was preceded, and the Third Amendment, you know, is quartering troops. It's military occupation. So that the Second and Third Amendments are designed to protect us against military subversion of our democracy. Madison's structural answer, his brilliant structural answer, was to say that in 1800 or in 1788, a standing army, socially, consisted of the caste apart, a group of wealthy or aristocratic officers, and a group, the people who were the enlisted men, by and large either drawn from the prisons or from the workhouses, but they were certainly not a representative body. The army didn't look like the people. The standing army did not look like the people. And so Madison says when there's an imbalance, when the standing army doesn't look like the people, it's going to turn on the people. Because there's no linkage. And so we need a Second Amendment to protect the people from the standing army turning on it. Madison's idea was to create a shadow army. And the shadow army was the well-regulated militia. The shadow army was the entire people in arms. Everybody got to be in the militia. It was one of the great inclusionary egalitarian notions. Everybody got to be in the militia. Catholics were in the militia. Jews were in the militia. Everybody was in the militia. And they were armed because they were there in case the standing army moved against the democracy. The reserve army of the people would be used to deter them or, if necessarily, defeat them. Now, along comes Napoleon. Napoleon changes the idea of what a standing army is, both forever, because under Napoleon, the army becomes not this group of people apart from the polity; it becomes the nation in arms. He mobilizes France as a nation in arms, and then the United States comes along in the Civil War and perfects the idea in this terrible tragedy, where the peoples of the two sides mobilized themselves into armies that absolutely represented the population and then killed as many of each other as they could in the war. So if you end that and you say to yourself, do we need a militia anymore? Once the army, once the military becomes essentially a picture, a representative picture of the people that it is supposedly serving, that's the point at which the well-regulated militia drops out of American life. We no longer have it because there's no perceived need for it. So when the cases came before the Supreme Court, the question is, well, what role does the Second Amendment have in the 20th or 21st century? And the liberals made a terrible mistake. They said no role. They said once the well-regulated militia dropped out, because we don't need it anymore, the Second Amendment is an anachronism and a historical, just a holdover. We don't really need it. I thought to myself, if I have to choose between a reading of the Second Amendment that says it has no real meaning and a reading of the Second Amendment that says anybody gets to own a gun, guess what? I'll choose anybody gets to own a gun, because I don't want to erase portions of the Bill of Rights. I don't want 10% of the Bill of Rights to be relegated to historical anachronism. But that's because they weren't reading it under the Madisonian way of looking at it. If you look at it under the Madisonian way of looking at it, the way, at least my way of looking at it, that I claim is Madisonian, I can get away with that only so long. If you look at it that way, then you say to yourself, well, what's the modern meaning of the First Amendment, of the Second Amendment? And the modern reading of the Second Amendment is to say that everybody has a right to serve in the organs of armed coercion. Gays have a right to serve. Women have a right to serve. Blacks have a right to serve, because the great Madisonian understanding that's what the Second Amendment is all about, is that we can never allow a divorce to occur between the organs of armed coercion and the people that they represent. And this is true whether it's 18th century Virginia or 21st century Ferguson, Missouri. That when you have a divorce between the armed organs and the people, the armed organs will turn on that portion of the people who are not represented in the military. And so Madison's lesson to us in the Second Amendment is avoid armed subversion by making sure that the guys with the guns look just like the people they're representing. And that's the way you stop it. That's the modern reading of the Second Amendment.
I don't know, Bert. Think about that. We have dictatorships all around the world that are drawing from the people, whatever those people are in each of these countries. And those people, look at Syria, look at any of the others, where dictators are turning on their own people and killing them. So it hasn't worked in those places. I don't know that Madison would have thought that a Second Amendment that applied just to the idea of an open army, presumably, well, he wouldn't have thought of it because blacks weren't included in the Constitution, women weren't. I'm just trying to think why that reading really protects democracy.
Well,
Maybe we've got those holdout people who are, fighting off the government on their ranches. So.
Well, let me take that in two sections. One, I'm not sure you're empirically right by suggesting that that armies that overthrow democracy tend to be representative armies. I don't know enough about it to be sure, but my intuition is that when you have democratic overthrows, they are often overthrows by one group as opposed to another group. That armies that really do look like the people they represent are the least likely to turn on the polity. And the second is that I don't know what the modern analog of there are three. The second one is, you don't seriously think that we're going to protect democracy by giving everybody a chance to own a .22. I mean, if we ever have real problems in this country with a government that is oppressing us, that there's going to be real problems, I think it's a teenage boy's fantasy that what you're going to have is ad hoc groups who will organize to defend with small arms against a military armed with tanks and bazookas, unless you want to say that the right to bear arms means the right to have your own controlled nuclear weapon that can really fight back. And nobody argues that. So I think it's a fairy tale to say that we defend democracy by allowing people who want to have small arms. Now that's not to say, by the way, that I don't support the idea that you don't disarm people lightly. And that owning guns means a lot to people. I think where the court went wrong in the Second Amendment was McDonald, where they insisted that the Second Amendment was applied against the states. I would have had it apply against the federal government if you insist, but then I would have allowed each state to make a local judgment about the need for regulation, and let the people in Wyoming remain secure that they can have their guns forever. Because no one's going to take them away. But let us do something about the epidemic of guns in the inner cities. But that's a long.
I'm going back to the ninth a second.
We'll do one last question, Justice. Yeah. No, go ahead. Yeah.
You talk about, as I indicated earlier, greater protection of rights, less federal government control, and you even suggest that where in the heck did we create the right of the federal government to seize property under the eminent domain clause?
I don't think they have it.
Yeah, it's clear that's what your argument is. Where,
I think it's a local power, but I don't think it's a federal power.
all right, so tell me what other powers have been recognized that your approach would do away with?
Well, the one that jumps out at me is and this of course comes from my own experience in my career, the astonishing abuse of the war power by the executive. The growth of an executive branch in this nation that believes that can commit American kids to die overseas on its own without any serious legislative authorization. I litigated the war in Vietnam. I'm enough of a romantic to have actually run into stone walls arguing that Vietnam was a war and that Article 1, Section 8 meant what it said. And that it was outrageous to say that just because Congress lacked the stomach to be able to end it, it would vote appropriations, and that would be the equivalent of an Article 1, Section 8 declaration of war. And then we have the War Powers Act that was supposed to help with that, but the combination of the appalling congressional refusal to live up to its responsibilities, one way or the other, their desire to let somebody else take the responsibility for everything, and an overly aggressive executive willing to commit troops abroad, I think has created a very dangerous problem. The last one is surveillance. I think surveillance is absolutely out of control. Whether the genie could ever be put back in the box, whether technology has ended any conception of privacy that we ever may have again, is a hard question. But I do know this: the ability to say that surveillance is not a search, and therefore I don't have to get a warrant, can only be read if you don't read the Fourth through the Eighth Amendments as a seamless whole. If it creates white spaces in there for the government to sneak through, I think we deserve what we get.
This has been a fantastic conversation. Thank you to both of you.